To the compliance guy. Today is Tuesday, the 9th of August in the great year of 2022. And that means it's time for another hashtag Terry Tuesday episode on the compliance guy. As always, I'm your host, Sean Weiss, and I want to begin by saying thank you all so much for tuning in, logging on, and just hanging out with me and Terry for a little while. But today we have a special guest. And I think this is actually the first time on a hashtag Terry Tuesday episode that we've invited somebody else to hang out with us because normally between Terry and I, we're struggling to keep these things, to a reasonable amount of time. And now we're throwing a third person into this thing. So it's going to be kind of interesting to see how this thing plays out. But let me introduce you real quickly to our special guest. And then I'll come back to my other special friend, Terry, and we'll just talk all about how amazing she is. So joining us today is Karen George. She's an attorney at Buchalter in Los Angeles, and she's a member of the firm's healthcare practice group. Now, Karen specializes in managed care contracting. So as I'm sure you all can guess, today we're going to talk about contracting. We're going to talk about payer contracting because we are entering into the season of giveth and taketh away. So she is specializing, as I said, in managed care contracting and routinely represents healthcare providers in large exposure reimbursement disputes and litigation against payers. Karen engages a lot in out-of-network reimbursement disputes, coverage disputes, coordination of benefit issues, and recoupment demands. She represents a very diverse array of healthcare providers, including hospital systems, physician groups, ASCs, urgent care centers, outpatient clinics, as well as billing companies. And as everybody is getting more and more adept to the world of telehealth, she's engaged in a lot of that as well. Now, Karen, I know you've resolved a lot of significant disputes with payers, recovering millions of dollars on behalf of providers in civil actions and arbitrations. So I'm really excited about having you on the podcast today. As everybody knows, I usually don't introduce Terry beyond just here's Terry. Because I mean, what am I supposed to say about it? I mean, the woman's a podcast giant. She's, a subject matter expert in the world of coding and billing and auditing. I mean, she's Terry freaking Fletcher.
Oh
I
my
mean, how
gosh.
much more of a
Let's just
bio
keep
do I
going
have
now.
to?
Let's get
How
to
much?
the show.
How
Shoot.
much more of
I
a
did this
bio
to
do I
people. I
need
was
to
like,
give?
hey, can I get a bio? And this is what I get. Okay, let's go, Sean.
All right. So, ladies, it's so good to
This is
see
what you
you.
asked for.
Yeah. It's really interesting. Terry got some direct messages, and I got a bunch of emails and direct messages last week from people going, are there no podcasts this week? Well,
Yeah.
there weren't. And there's a reason for it, but it's none of your business. So we're
Sean was out on assignment.
I was out. I was detained. Let's just put it that way. But we are back this week. We have an incredible week of shows. We had an incredible Monday coding and compliance roundtable with Terry, Paul Spencer, and Scott Kraft. I know we had a lot of folks on that. And the rest of the week, we have some great stuff. So with that said, Karen, welcome to the program. It's such a pleasure to have you joining us. I know we've been trying to get you on for a couple of weeks now, and it finally worked out that you're here. So welcome.
Thank you. Thank you, Sean. Thank you, Terry, for having me. Happy to be here and discuss all things contracting.
We love when our attorneys can join us for sure.
Yeah, definitely. As if we don't have enough legal stuff to talk about.
I know, right?
Let's just add one more attorney to the mix.
I know,
Karen,
right?
Karen, we treat all guests on the show identical, and it's
just wait.
just wait till you start to feel the vibration and the wheels starting to come off. But
oh God.
so as we had a couple of minutes to talk prior to the show starting, Terry brought up a very good point. we're entering into the season where most people are getting ready to make a determination as to whether they're going to continue participating in their current contracts or whether they're going to go back to their payers and say, "Hey, wait a minute. We need to talk about the terms and conditions. We need to talk about how you're processing our claims, how you're adjudicating our denials, whether or not we believe the reimbursement rates are, fair, which is always subjective and open to interpretation. Are there gotchas in the contracts, such as most favored nations clauses, which we're starting to see more and more of those as capitation starts to rear its head once again. We were talking about this not too long ago with the 2023 CMS framework, um, whereby they're announcing that they want all Medicare beneficiaries in an ACO by 2030. And of course, that's to do what? Control costs and to control the output of care. So let's pause for a second and let me just say, Karen, on a macro scale, and then we'll kind of dive into it. On a macro scale, what are you seeing from a contracting standpoint that providers and their leadership need to be aware of?
Yeah, definitely. I think one of the bigger, just on a macro scale issue we're seeing is initially when providers are entering into these contracts with the payers, they are not pushing back on certain terms that need to be pushed back on. They're often faced with a boilerplate template from the payers, and they recognize that they do have some leverage, but payers often have a lot more leverage than these providers do, and they're signing contracts without really doing a deep dive of what's in there and what are these terms looking like, and really what are certain things that they're able to push back on. And I think that that's one of the biggest thing we're seeing. And so when it comes time to renegotiate these terms, I think it's critical for providers to go back to their revenue cycle personnel and talk to them and see what sort of issues are you seeing on your end that we need to come back and push back on. Simple things like the timeliness of claim submission, for example. So many things are, unpredictable and occur in this world where a provider may bill, the wrong insurance company, for example, because the patient gave them the wrong payer. And so you end up, until the timeline between you initially billing the first insurance company to when you finally get it right and bill the correct one is a really long period of time. And oftentimes you don't have that much time built into your contract where you end up having a timely filing denial, within 30 days. So it's really critical for provider to go through and identify these points to go back to the payer and renegotiate some of these terms.
So you raise a really good point, right? And I want to make sure that, for our listeners, because, we do have a lot of attorneys, so they'll be more familiar with some of the statutes and laws and things that you're talking about. But I think it's also really important for folks to keep in mind that when we're talking about the Clean Claims Act, we're talking about 42 CFR 447.45, right? So that's the Code of Federal Regulations. That is where the timely claims payment act or laws actually live. But it's critical to keep in mind that there are state specific claims processing laws. So for example, Karen, you're in California. So
Right.
can you talk a little bit to the requirements in the state of California?
Sure. So, under the Knox-Keene Act for claim submissions, you have at a minimum 90 days for a contracted provider to submit a claim and 180 days for a non-contracted to submit a claim. And so you want to make sure that your contract complies with that you're not, putting in any provisions that restrict, that are lower than 90 days for claim submissions. And you want to obviously try to get additional time because that's just the baseline that the state requires. On the claim payment side, we have, again, under the Knox-Keene Act, it is HMOs have 45 days to pay a clean claim and PPOs have 30 days. And to the extent these payments aren't timely made, there is a 15% interest penalty that's in there. So again, it's really critical for payers in different states, for providers in the different states to know what their prompt pay acts look like and what are the requirements under them, and build that into the contract. And to the extent that you're able to negotiate additional days or a higher interest penalty, then that's really important. I mean, we have a client right now in Massachusetts, and it's a really unfortunate event. What's happening is that the payer actually audited a lot of the claims, determined that they had upcoded 98%, which is really interesting. So we are going through and doing a deep dive into that. But what's happening right now is that every claim that's being submitted is on hold pending an audit, has not been denied or paid. There has not been an audit determination, and we're talking about 8 months worth of claims. So now the provider isn't getting any payments from the payer for these claims, but on top of that, can't even bill the patients for their cost sharing portions. And we know that the further out you are from a bill, the less likely you are to collect from a patient, any amount. And so the provider is just sort of stuck in limbo right now, not really knowing what to do. And so, but this is a non-contracted provider, right? So there are no terms governing the parties' relationships. And so on our end, we're looking into Massachusetts law. Is there statutory framework? Are there certain restrictions on when a payer must pay, and are there interest penalties? What is the provider manual for the specific payer, have about these restrictions? So
Yeah.
really,
And so you mentioned 2 terms, and I wanna quickly make sure that we define those for our listeners and our viewers. So, obviously, you use the term claim, right? So and you use that synonymously with a term, bill, right? So it's a bill for service.
mhm,
It includes a line item of service. It includes all services for one beneficiary within that bill. But the other term that you used, and I think this is so important, is for people to understand what the term clean claim means, right? So a clean claim means that it's one that can be processed without obtaining additional information from the provider of the service or from a third party. So it includes a claim with errors originating in a state's claim system, but it does not include a claim from a provider who's under investigation for fraud or abuse, or a claim under review for medical necessity. So, it's important to keep those in mind, because a lot of providers are going to say, "Well, I submitted a clean claim." Well,
right.
you know, what is the definition of a clean claim under 447.45? Now, Massachusetts is an interesting area, and Terry, I want to go to you on something, because what Karen was talking about is the fact that basically the provider's under a prepayment review. And what we have seen with prepayment reviews is that there is no level of justice, if you will. I mean, you're basically subject to, the discretion of the payer. Now, 8 months, Karen and Terry, I think we all agree that's egregious, and that's unreasonable. And the Commonwealth of Massachusetts is very interesting. I do a ton of work up there, but Terry, what are you seeing? Are you seeing providers going through the same kind of nonsense where, they were, an allegation was made against them for upcoding their services, and then all of a sudden they were put on prepayment review, and there's no processing of the claims? Are you seeing that as well?
I am, and it's interesting what Karen was saying, because I'm even seeing it to the extent that she's dealing with Texas, Florida, and California. And I've had to I don't want to say work around it, but make it where you're using certain language in your communication with that payer, so that if it comes back where you need an attorney to help you fight it. So what we do, or what I recommend to my clients, is we use the term either acting in bad faith or acting in good faith. And payers hate the term bad faith. That it makes their hair on the back of their neck stand up. It's also a government term that we've seen in a lot of the telehealth fraud recently. So in that scenario, I actually had 2 of those kind of claims and kind of those situations in Texas, and we had submitted information to the payer and said, you cannot hold on to the claims. It was a year. I said, you can't. You're acting in bad faith. these claims are appropriate, they have coverage for this, and now you're impeding on the timely claim submission, and exactly what Karen was saying, and we can't get the share of cost from the patient, and after a certain period of time, we're going to be out of luck. And so kind of went back and forth for a couple of months, and I can't tell you how many times, bad faith, bad faith, bad faith. And I brought the patient into it because it's their insurance, and said, you need to file a complaint also with the insurance commissioner. And it's hard because the Department of Insurance in a state will only listen to it if it's a commercial plan, some HMOs, some self-insured, but there's certain claims they're like, we're not listening to them. Like, they don't like to listen to anything Blue Cross Blue Shield. They're just like, oh, well, they're different. I'm like, well, how are they different? So anyway, we've done that, and we've had some success with it. We've had a good amount of success, basically trying to get them to understand that either pay it or deny it or do something with it, so then we can do something with it on our end. And and that's been some success. But what's tough, and going back to what Karen was saying, is when the providers, the hospitals, the practices give up, or they feel they don't have a place to go, or they don't have an option. And we're here to tell you, you have options, not only engaging in a healthcare attorney. And I know that can get costly, but just think of how costly it is to let it go and then never be able to change the behavior. So you have to engage sometimes in an expense to get the behavior of the payer changed.
Yeah,
Absolutely.
that's a really good point. And I tell people, look, the only way sometimes to get something done with a payer is to rattle the tree. You got to shake that tree a little bit, and you got to see what falls out. And the only way to be able to do that is to get a healthcare centered, experienced attorney in contracts. Now, this is the thing, and Karen, you tell me your thoughts about this, right? So there are so many different tentacles coming off of this, 27-headed monster, which we call the healthcare industry. And, for me, you know, I don't necessarily want somebody who specializes in white collar criminal activity from a healthcare standpoint, who does trial law, litigation, engaging in transactions on my behalf, or engaging in contract negotiations. Because would you agree with me that there is an inherent difference between the administrative functions in healthcare, right? The transactions, the contracting, versus the litigation for civil or criminal matters?
Yeah, definitely, Sean. I think that that's critical. You want someone who has engaged in contracting with payers and is aware of all of these different terms and how they apply on a day-to-day basis. I will say though, it is also helpful to have a litigator. So I do a little bit of both, right? But I do a lot of litigation against payers with respect to contracting. And so from that perspective, it's really critical to go back through and look at the contract, because I have seen where things have gone sour with the payer and where the points of contentions are, and oftentimes what ends up leading to that dispute. And so being able to look back at a contract when it's from its inception, having seen how it terminated and what went wrong with the process, can also be really valuable and give additional insight than just a transactional attorney who handles it on the front end of the deal.
Can I ask a question, Karen and Sean? I hope this is okay.
Yeah,
We
please.
since we've there's Now that we're getting into contracting, and I really love this topic because we've been all through this pandemic. And what have seen, and I think this is interesting. So at the beginning of the pandemic, we saw the payers, basically, so they weren't mandated, going, "Oh, we're going to cover this. We're going to cover telehealth. We're going to do this for you." I think mainly so that the government, HHS, didn't go, "Yeah, you are doing that." So they kind of threw a bone out there before they were told they had to. But what I'm seeing is that in a lot of commercial plans, there is a paper for performance bonus, or things like that for the physicians, based on how they save money or how they treat patients. But now what I'm seeing is that because a lot of the practices were shut down, we were mandated to quarantine or all that, they didn't meet their quota. And so the payers are making a ton of money, but the doctors now aren't getting their bonuses based on the contract language. And now the payers aren't being like all this nice and yeah, we were in a pandemic. Now they're like, you know what? Pandemic fatigue. We're in the third year of it and you didn't meet your contract, so we're not giving it. How does a provider, I guess, moving forward? Well, first moving backward, how do they actually try to negotiate to get that? But then moving forward, what kind of language do they need to include on, pay for performance and some of these I'm missing my words here, something regarding tied to how they treat patients if there's another pandemic. What should be inclusive of those, contract language?
Yeah. I think going retrospectively, I think to your point, Terry, one of the issues is that providers are not willing to push back. And I think that that's really critical is going back and seeing, where are the gaps and what are they missing and how can we push back on it? And part of that is also including dispute resolution, good dispute resolution clauses in your contract, making sure that, you're getting, the statute of limitation is not limited more than what your state requires for you to go back and collect on. If there's an arbitration clause, making sure that it's a one arbitrator as opposed to a panel. You don't want additional fees. Each arbitrator's fees are like, they can get really significant. We're talking about like $8,000 a day, right? Don't have three arbitrators.
Wow.
Wow. It can get extremely expensive. Maybe having some informal dispute resolution in advance, prior to having to initiate arbitration. So I've seen some contracts where they include maybe mediation in advance. So the parties are forced to come together for a day, sit in front of a mediator and work out whatever conflict there is and come to a resolution. Even before that, there can be an informal meet and confer process where, the parties, the provider will send a letter to the payer and they will meet, have either a phone call or Zoom or in person and discuss these differences and try to come to some sort of agreement. So I think that that's definitely an important step one, to include that language in your contract. And I think in addition to that is, having clauses in there for when things like a pandemic arise, you have like a safe harbor in your contract to account for certain, unexpected occurrences that might arise.
So, you're bringing up a lot of great points, and I know because I know our audience, and I know a lot of the physicians will reach out to me and say, "Sean, this all sounds great. Are the insurance companies really gonna go for this stuff?" And the answer in my experience is yes. They will, and they will at least listen to reason, and they will be accommodating because 90% of physicians out there in private practice or small group practice don't negotiate their contracts because they believe what I get is what I get, and I'm just stuck with it. And, to me, I tell physicians all the time, I know you guys don't like to hear me say this, but it's the truth. Y'all have been your own worst enemy. You know, when contracting was, when we were looking at contracting in the late 90s and into the mid 2000s, you know, physicians would go back to an insurance company if they were told our panel is already full, we're not letting you on. They would go back and say, "Hey, how much are you paying Sean Weiss down the street? I'll take a 10% reduction over what you're paying him and I'll make it more cost effective for you." And what happens? All of a sudden now they're opening up that panel for that doctor, and Sean Weiss is being sent a notice that your time on our panel is over. And so that cutting each other off at the kneecaps, if you will, has always been something I try to tell physicians you can't do. But what? So
Let me chime in
obviously,
real quick while you're
yeah,
thinking.
go
Let me
ahead.
chime in real quick. I think one of the things that's really tough too, and this is for our listeners, just know that when we talk about negotiating contracts, when we talk about contracting season, we're not just talking about reimbursement. You've heard things that Karen has been talking about, that Sean's been talking about. We are talking about contract language and finding those gaps, such as how long do you have to submit a claim? And you brought up a great point, especially I would think for hospitals who get the wrong insurance a lot. And then the patient gets treated, and all of a sudden they're like, where'd the patient go? And there's no insurance. And now they've got to spend, weeks, months, whatever, trying to find that. Happens occasionally in physicians' offices, but not as often, I would think, as in hospitals. But things like that, things like the Prompt Payment Act, things like arbitration, if things go wrong, like you said, a dispute resolution or some kind of clause, if there is an argument to be had, or something that happens that you don't have foresight into. We didn't know the pandemic was going to happen. I mean, maybe some people did, but from a healthcare reimbursement contract perspective, I think there's a lot of physicians out there going, oh, shoot. I mean, we had to pivot just to get people to work from home, and they're at their dining room table. Don't even get me started on the HIPAA issues there. But so, one of the things that I think is really important as we're talking about contracting is there's not just, again, reimbursement issues. Yeah, that is a big part of it. Don't get me wrong. But you also have to look at, and I deal with this with a lot of orthopedic and cardiology practices, what specialized services are you doing that don't have specific codes or have new technology T codes or whatever, and you want to have them included for at least consideration. And I'm noticing a lot of doctors are like, I didn't even think about that. Didn't even think about it. What is the clause in there to add a new doctor to a panel, like Sean was saying? Are you closed just to the physicians that are here? What if we add nurse practitioners, PAs, or physicians? Will you open it to our practice? Is there something in there about that? Is there an incident to guideline that you're liking to Medicare, or can we bring them on out? What's the credentialing process? And again, I think to Karen's point, it's amazing to me how people look at credentialing and contracting as a one issue thing, and it's not. It's so much more than just that. And Sean, I'll throw it back over to you, and also Karen. She brought up a good point, bringing in the revenue cycle management staff. Should this contracting be done by a physician? You've got small practices sometimes that the doctor doesn't have time. You've got maybe an office manager that is a relative. You've got, maybe some staff that could be pretty, and I'm trying to be politically correct here, pretty green and understanding. I mean, contract law I don't do contracting anymore, except I consult on it. I'll basically say, okay, who can I refer this out to? So I'm like, I don't want to do it, but I deal with it within my client base, just saying, okay, here's, I give them a guideline, and then I give them a referral you to go to. But who should be in charge of it? And I'll throw that back to you guys.
Go ahead, Karen, please.
Yeah. I mean, you make a great point, right? It's oftentimes these physician groups or just a solo physician are a lot smaller, and the resources just aren't there. And I think it's really critical to outsource that and to work with someone who has the knowledge and the experience that you just may not have. Because what you were talking about earlier is a lot of times they're just thinking, the providers are just thinking it's just what the rate is at the end, and that's all that they're looking for. But they're not, taking into account all of these variables that actually are going to affect the rate significantly more than they're, led to believe. We had this interesting situation come up a few years ago where the physician negotiated the contract with Anthem on his own. And then, when it came time to sign, he did come to us and said, I just want you to look at the contract, make sure, everything is good to go before I sign. So we're looking through it, and we're not seeing the rate sheet. And there are no rates anywhere in the contract. And so we go back to him and we're like, hey, I thought that you negotiated a really good rate. Where's the rate? And he goes, oh, it should be in there. Like, it's not. So he goes back to Anthem and he's like, can you please attach the rate sheet before I sign? And they say, no, you have to sign first, and then we'll attach the rate sheet.
And you have to sign first.
He didn't thankfully sign, but can you imagine?
It reminds me of the piece of legislation where Nancy Pelosi from your great state of California said, oh, we just need to pass it, and then we can read it.
And then we can read it. Oh my
gosh. It doesn't work that way.
Now, this is a good reason why you need to have a third party or somebody else's eyes at least looking at it.
So I want to talk about something else. that Terry brought up prior to us getting started, and maybe we'll make this the last part of our discussion today. The disparity in contracting rates. You could have two providers, same specialty, same subspecialty, same training, same years of practice, same skill sets, whatever you want to call it. And one provider is being offered a rate higher than the other provider. And to Terry's point, where she has seen this, and Karen, I'm guessing where you do a lot of this work, you're seeing this as part of a gender gap.
I have seen that.
The difference between what male physicians versus female physicians are receiving as pricing for their services. Karen, what are you, Terry, I know you've seen that, and we'll come to you in a second. Karen, what are you seeing, and how would you suggest providers address that?
Yeah, Sean, it's a really unfortunate thing that we're seeing. The gender gap really everywhere, and especially in the healthcare industry, is wide. And some just suggestions or recommendations I would have for that is for more aggressive negotiations to take place and more data-driven rate negotiations on that end as well. Looking at fair health, trying to get an idea of what providers who are in your geographic area are paying, and presenting that to the payer as additional data-driven, backed up information as leverage to use. Because what we're seeing oftentimes is some providers are willing to be more aggressive with their negotiations and with their rates, and others will just accept what the payer are giving to them. And so I think if you're able to do more research on the front end prior to engaging in this negotiations, by again looking at data sources, external ones, but as well as internal ones, seeing what you're receiving from other payers in the regions, seeing what your most common procedure codes should be and are paid at, and using that as support for negotiating a higher reimbursement rates. And again, looking at what other providers who are comparable to you are getting paid, to set that in front of the payer as a negotiation tool. So those are some of my advice. And Terry, I throw it back to you. I know that that's something that you've been dealing with a lot lately.
It is, and actually OB-GYN and internal medicine is the specialty that I'm seeing it in. I saw it in one cardiology practice, and they just said, "Can you just look over our contracts? I know you don't negotiate anymore for us, but can you just give us some insight, because we're going to negotiate and do that." I'm like, "Sure," so I still do that. And I'm looking over this and I'm like, "Wait, this can't be right." And I'm saying, "Okay, why is this doctor getting paid 12% more?" And then I just happened to look, and I said, "Oh, okay, we've got a gender gap going on here," which I didn't think that still happened really in healthcare, but it does. And so one thing I do appreciate, and I think this has just shown the steps coming so far. When we reached out to a couple of male physicians that were like specialty, that were not in the same group, we just said, "Hey, could we just talk to you about your contract? See, we're trying to compare where ours are so we can do some negotiation. We're seeing a gender gap disparity." And the doctor's like, "You're kidding." Absolutely. And so a lot of the male female issue thing isn't an issue for male physicians. They've been great. They've been just like, "You should not be, reduced because of that." So that's been really helpful. But again, to your point, it's being aggressive in your negotiation, but you have to identify the problem. And a lot of times the doctors don't know it even exists until a third party, somebody like any of us, come out and really take a look at it and go, I'm seeing something I don't think you're aware of." One of the things that I see most often is on just getting out of that conversation, are on evaluation of management services. I'm noticing that people are negotiating under the Medicare fee schedule. Why? Why are you doing that? That should be one of your lowest fees in the office. So I get confused when people don't have a kind of a threshold, at least above the Medicare fee schedule. I had one office says, "Well, we use actually Medicaid." I'm like, "Oh boy." Why? How can you afford me? No, how can you afford any outside services if that's what you're doing? So, yeah, so it's trying to give them also a starting point of what to negotiate, and allow for the cost of living and stuff. But I think I know we need to wrap this up. I think as far as my last words on this, make sure that if you are not, and I don't want to say experience, because that's not the word I'm using. If you're not comfortable looking at your own contracts, if you don't feel like you can gain optimize your contracts in your favor, whether it be your reimbursement, your specialized area, make sure you're looking at, pandemic issues for the future, pay for performance. I can't seem to say that. Timely claim submission, anything like that, dispute resolution, gaps, whatever, you need to get out a third party, because in the long term, you may think it's an expense now, but in the long term, it's going to save you and really make you so much more money and keep you viable as a practice versus letting it go. I mean, think of what Karen just said. Somebody said, "Oh, can you just take a look before I sign this Anthem contract?" And there was no fee schedule in there. Can you imagine if that doctor actually signed it? Oh my
Yeah,
gosh,
and
Sean.
and you know what I would say is, for me, no matter how many contracts I've looked at over my career, I always want a second and sometimes a third set of eyes looking at it, because I may be looking at it through a polarized lens where I'm focused on something very specific that I know our client has had issues with or taken exception to in the past. So I'm trying to figure out a resolution for that, versus somebody where if I were to say, "Hey, Karen, you know, take a look at this contract. What are your thoughts?" Because I've been so singular focused on one particular area, I may have completely overlooked other areas that are even more relevant and important for the practice to be able to, take, get clarification on. So, Karen, let me ask you this in the last couple of moments that we have together. What would be your takeaway message for our viewers, our listeners today?
Takeaway is, make sure that you do your research prior to negotiating any contract. Have an understanding of your geographic market. Have an understanding of your data, your revenue cycle management, what other providers are getting in the same region. You know, gather that research in advance, and then once you come to the table with the payer, make sure that you're reviewing the entire contract and all the terms that are in there, and look for places that you recognize you're missing in your practice that you need to push back on. Having done that research, you should come to the table knowing what it is that you want to get out of this contract negotiation. And to Terry's point, don't just skip to the last page of the contract and look at the rate sheet. Read the rest of the terms and see where you feel like you have to push back and where you're willing to compromise and let go. And then come to the rate sheet part, and let's negotiate rates again based on that research that we've done, based on the data that's out there. And don't just come to the payer and say, "Hey, I want more, I want a higher rate." No, bring that evidence with you and say, "I need a 2%, 5%, whatever increase, or I need a different rate structure because, quite frankly, I'm looking at my patient population. We've got a lot of, Medicare, more Medicare than commercial. So let's do a blended rate, right? As opposed to a fee for service, or, different rate structures depending on what sort of patient mix that you're seeing." I think that that's also really critical.
Awesome. Such a great conversation today. Great way to end this episode with some invaluable takeaways that I think our folks who are responsible for contracting on behalf of their practice with the payers can look at as tangible takeaways, things that they need to be aware of, things maybe they weren't, and understanding that there are people who specialize in this kind of contractual work, this transactional kind of work. So, Karen George of Buchalter Law Firm out in California, thank you so much for joining Terry Fletcher and myself today on this hashtag Terry Tuesday episode on the Compliance Guy. So great to finally have a chance to sit down with you in person to get you to share your thoughts with us. Terry, thanks for making this introduction with Karen and getting her to be part of our program today.
Thank you.
We are
Thank you
so
so
happy
much
to have
both
her.
for having me. This was
We're
great. I
happy to
really
have her.
enjoyed it.
Awesome. All right, that's going to wrap up this episode of The Compliance Guy. As always, thank you all so much for tuning in, logging on, and just hanging out with Terry and I for a little while. We'll be back next week with another hashtag Terry Tuesday episode. So until then, be good to yourself, but more importantly, be good to each other. Take care.